Welcome to Employment Law This Week. I'm George Whipple. Non-compete agreements are generally unenforceable on lawyers, but there are some exceptions. Today, we'll discuss employer options for restrictive covenants, including non-competes, non-solicits, and confidentiality agreements for both in-house and outside lawyers. While there are no national ethics standards, all states, except California, base their ethics rules on the American Bar Association Model Rules of Professional Conduct. So does the District of Columbia. These rules generally prohibit attorneys from participating in agreements that restrict their right to practice law after termination. Epstein, Becker, Green's Millie Warner has more.
Under ABA Model Rule 5.6, an attorney cannot participate in offering or making a partnership, shareholders, operating, employment, or any other similar type of agreement that restricts the right of the attorney to practice law after termination of their relationship, except for an agreement concerning benefits upon retirement, or an agreement in which a restriction on the attorney's right to practice is part of the settlement of a client controversy. So this rule is intended to protect an attorney's professional autonomy, as well as a client's freedom to select the counsel of their choice.
Millie talks more about this on Epstein, Becker, Green's podcast series about trade secrets and non-compete law, Spilling Secrets, available on the Employment Law This Week podcast feed. She says the ABA rule has been applied pretty consistently when it comes to law firms. Most cases and ethics opinions have held that non-competes are unenforceable between attorneys. But like Millie mentioned, there are some exceptions. The retirement benefits exemption allows attorneys to agree to restrictive covenants in exchange for payment of retirement benefits. This only applies to an attorney actually intending to retire or otherwise winding down their practice. Epstein, Becker, Green's Kate Rigby outlines another exception.
There's also a sale of practice exception in certain states. So states like Alaska, Arkansas, Hawaii, Idaho, New York, and Maine will permit attorney non-compete agreements relating specifically to the sale of practice. So those are a couple different exceptions that, again, are limited and still need to meet certain requirements within each.
Rule 5.6 does not distinguish between in-house and outside counsel, but in-house counsel frequently serves the company in multiple areas, such as in human resources. This creates a bit of gray area. Because the rule only applies to the practice of law, employers may require signed agreements that restrict in-house lawyers from competing with them in other areas, as long as it doesn't affect their ability to practice law. When it comes to trade secrets, however, Epstein, Becker, Green's Erik Weibust points out that the law is clearer.
The laws related to trade secrets, whether it's the DTSA or the Defense Trade Secrets Act, or a state version of the Uniform Trade Secrets Act, apply equally to lawyers as they do to other employees. You can be sued for violation of those laws. Of course, in the DTSA, there's a whistleblower carve-out. If you're a whistleblower, you can make certain types of disclosures, and that would presumably apply to in-house lawyers as well. But typically, you can be sued under the trade secret laws if you misappropriate.
Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.